The Law Society of America has become a prominent voice in the ongoing debate over the United States deportation of foreign criminals, including those sent to African countries. The organization, which represents legal professionals and advocates for the rule of law, has released a detailed analysis of the policy, highlighting both its legal framework and the controversies surrounding its implementation. According to the Law Society of America, the U.S. government has broad authority to remove non-citizens who are convicted of crimes under federal immigration law. This authority is primarily derived from the Immigration and Nationality Act (INA), which allows for the deportation of any foreign national who has violated the terms of their stay or committed certain offenses. The law is clear: if a person is not a citizen and is convicted of a deportable crime, the government can initiate removal proceedings. However, this legal power is constrained by international agreements, human rights obligations, and the willingness of other nations to accept deportees. The process begins when Immigration and Customs Enforcement (ICE) identifies a foreign national who has been convicted of a crime. Once the person serves their sentence, ICE can detain them and initiate removal proceedings before an immigration court. If the individual has ties to a country in Africa, either through citizenship or birth, the U.S. will typically contact that nation's consular authorities to verify documentation and arrange deportation. In some rare cases, the U.S. negotiates directly with African governments to accept non-citizens who have lost their citizenship or whose status is unclear, although this can take years and sometimes leads to diplomatic disputes. The Law Society of America points out that while the policy is legal under U.S. law, it faces challenges under international law. International human rights conventions, including the Convention Against Torture, prohibit countries from sending individuals to places where they face a credible risk of persecution or inhumane treatment. In the context of Africa, this means that the U.S. cannot legally deport a foreign criminal to a nation where civil unrest, political persecution, or lack of legal protections could endanger their life. Immigration lawyers frequently raise these arguments in court, resulting in prolonged legal battles over individual cases. Beyond the legal issues, the Law Society also addresses the policy's social and ethical dimensions. Deporting individuals to Africa can have severe consequences for both the deportees and the receiving countries. Many of these individuals may have spent decades in the U.S., with little connection to the country they are being sent to. Upon arrival, they often face unemployment, homelessness, and social stigma. For African nations already struggling with economic and political challenges, the arrival of foreign criminals, sometimes with little documentation, can create additional burdens on local law enforcement and social services. American immigration courts have tried to balance public safety with fairness. Judges consider factors such as family ties in the U.S., rehabilitation, and the potential for harm in the receiving country before making a decision. However, ICE maintains a strong stance that public safety must come first. Officials emphasize that deportation is a consequence of breaking U.S. laws and that keeping dangerous individuals in the country would be unfair to law-abiding residents. The Law Society of America has also highlighted the political dimensions of the policy. Deportation of foreign criminals to Africa is often cited in debates about border security and immigration reform. Some lawmakers advocate for more aggressive deportation measures, framing them as necessary to protect American communities. Others call for reforms that would provide more due process protections, arguing that the current system disproportionately affects minorities and long-term residents who arrived in the U.S. as children. Recent cases have brought public attention to the issue. In one instance, a man who had lived in the U.S. for over 30 years was deported to Liberia after completing a prison sentence for a nonviolent crime. He had no family in Liberia and faced significant hardship upon arrival. Immigration attorneys and human rights advocates used his story to highlight the need for more humane approaches, including consideration of the individual's ties to the U.S. and the conditions in the receiving country. The Law Society's report concludes that while the deportation of foreign criminals to Africa is legal under U.S. law, the practice raises important moral, humanitarian, and diplomatic questions. The organization calls for reforms that would ensure greater oversight, transparency, and protection of human rights in the deportation process. This includes increased collaboration with African governments, better reintegration programs for deportees, and clearer legal pathways for long-term residents to avoid removal in certain circumstances. As the debate continues, the Law Society of America remains committed to advocating for a balance between national security and the rule of law. Their position underscores that protecting public safety should not come at the cost of violating international norms or undermining America's commitment to justice. The conversation around deporting foreign criminals to Africa is far from over, and it will likely remain a central issue in future discussions of U.S. immigration and foreign policy.